Can I use an older will to contest the new will? The short answer is yes. But of course, the court is going to look at all of the circumstances of both wills, because this is a matter that goes before the court almost routinely. An older will versus a newer will. As a matter of fact, DL Daniel is very involved in a matter like that right now. So the short answer is yes. An older will can be used to contest a newer will. It doesn't mean that the older will stand, neither does it mean the newer will stand. The court will look at all of the circumstances surrounding the making of the will. And I could immediately put in a plug here for wills. Once you know you're changing your will, the law requires you to destroy. Destroy doesn't mean putting a line through it or crumpling it up and putting it, just doing it like this and putting it in the garbage bin. Destroy means tearing up. Destroy means burning. So there is no trace of a previous will. So the issue of another will arising should not happen if it is properly destroyed.
Yes, good. Sound advice. Credit union beneficiaries still subject to probate.
Tell me so I could follow you as well. Just tell me the number.
Sure, that's 87. We're going up.
No problem.
So 87.
All right. So in 87, credit union beneficiaries still subject to probate. Generally, yes. They still want to see the LOA, letters of administration, or the grant of probate. But in some credit unions, they will give you a certain amount of the money without having received the grant.
Good.
I see more.
We have another. Yeah, sure. You saw one.
All right. So Shelley is asking, how do you destroy a registered will? In the first place, Shelley, you need to tell me what is a registered will. I think I know what you mean, but I want to hear from you. What is a registered will? And then I see Maureen Sukru. If I live, she probably means if I live. Or if a live-in caregiver. You go ahead, Mr. McLean.
If a live-in caregiver resides in the property of the owner as per his request for over 2 years, can that person make any claims from the owner after he dies? The owner already has a will in place for his children.
The short answer is no. Ought not to. And I'm seeing Shelley is now responding at the Hall of Justice. All right, so I suspected that's what you were saying, Ms. Charles Williams. But first, let me correct you. The will is not registered. Because we have to be careful how we use certain legal terminologies. Once we say register, we are referring to something completely different. That's why I wanted you to clarify. What you do is that you lodge your will at the Hall of Justice. It is not registered. So the will is in an envelope and you take it into the Hall of Justice for safekeeping until you're passing. And how do you destroy it? You cannot destroy it. What you have to do, you cannot go back and take it out. It's never retrievable. Your executor or executors will go in with their ID card, their death certificate, etc., and apply to have a copy of the will, and they will now use that for probate purposes. And I'm telling you that because from personal experience, one of my clients, a will has been in the probate registry for the past 50 years. So it's never removable. You want to change it, you have to do a new will.
Yes, interesting. Okay, we touched on this point. That was 85 joint tenants versus tenants in common.
Yes, we've done that ad nauseum in land law already.
Yeah.
One joint tenants, once one dies, the next joint tenant automatically inherits the entirety. Tenants in common, when one dies, the property or whatever has to be shared among the beneficiaries. So Ms. Shelley is correcting herself. Yes, lodged is the correct word. That's right. And it's not even filed, it is lodged. So you're correct, it is lodged. Ms. Charles Williams.
Yes. we on 81. Does marriage trump a will? Do a new will after marriage?
Go ahead.
Or does a new will after marriage?
So
Trump a will?
Yes, you are correct. Marriage trumps a will, but I hate to use that word in light of Donald Trump. But yes, marriage trumps a will, and yes, you have to do a new will after you get married. Unless in the will before marriage, you say that this will was made in contemplation of marriage to XYZ. You have to be very specific.
Okay, noted. Good to know. How can someone prove they were a common law wife and override by rights to my father's estate where there is no will?
How can someone prove they were common law wife? So let's stop there. To prove you were common law wife, you need to go to the High Court for a declaration of cohabitation. And whether override by rights to my father's estate, once the person has been declared by the court to be a common law wife, that common law wife will be entitled to whatever he or she acquired with the gentleman during their time together. It doesn't override your rights because the common law wife, once we have a declaration accordingly by the court, the common law wife is now a wife and generally may be entitled to 50% if there is no legal wife around as well. Because you can have a common law wife and you can also have a legal wife and you can also have children, all involved in the same estate matter.
Noted. How can someone prove they were common law? Well, I think we answered that. Doing the will yourself with a commissioner.
Yes, we answered, but let's plug in for DL Daniel. You come to DL Daniel and we assist you in filing your court documents to prove that you were common law.
Very good.
Right. Okay.
So doing the will yourself with a commissioner of affidavits versus an attorney, and we just answered that. So come into DL Daniel and you will be assisted, right?
So yes, you can do your will yourself with the assistance of a commissioner of affidavits, but just always remember a will is a legal document. And so the best person to prepare a will is somebody with legal experience. But of course, you can do a will yourself.
Because the wording of that will, as I've been told, right, can be very significant, right?
You are absolutely correct.
And there may be elements, the structure of the will. You may exclude things that should be there and include things that maybe shouldn't. So,
and you're correct. We were able to go to court on a will that said in the absolute discretion of the executor, And we were able to get the court to say it was way too vague. So you are correct. Languaging in a will is very, very important. Because what you think it may say, it may not say. This is why we had to assist Shelley earlier when she said a registered will. And then she corrected herself, lodged.
Yeah. So let's not be penny wise
and pound
foolish. It could cost you a lot of land or something else, right? Good. So I think we severely answered that. If a child adds on to his parents' house with their permission, the child has a family.
What number?
Sorry, that's 80.
Yes.
If a child adds on to his parents' house with their permission, the child has a family. Upon that, the section of the structure owned by the wife, or is it considered part of the parents' assets?
All right, so let's look at that again. A child adds on to his parents' house with their permission. But remember, it is still their parents' house. The child has a family. Upon death, is that section of the structure owned by the wife? Upon whose death? or is it considered part of the parents' assets? It's the parents' house. If you can chop off the part you added on and go with it, fine. I don't think you can. And so you have to be careful how you do these additions. And you need to make sure that the parents would have said the annex built by X belongs to X and will or something like that. Because we are in family type situations, they're all very nice and fluid, and we move into these very, very serious. And this happens, this is a family situation that is extremely, very, very prevalent. And it's very dangerous because the proper legal structures were not put in place for the addition of the annex. And now that my father is dead, my father's wife, who is not my mother, is saying the entire house is hers.